Alright. Right now I'm picking up, I think, in udaap. I started reading about Reg AA, what it covers and doesn't cover. Did I? I did. And then I talked about unfair act, and how we have to bill the customer 21 days before the due date. Okay. The grace period is nice. And how to allocate payments if they make it more than the minimum payment. And I think I left off, I would just hope I left off it regarding increases in APR general rule. At account opening, institution may disclose all APRs that will apply to each category of transactions on the account. These APRs cannot change except as the rule follows. Here's the exceptions. The rule prohibiting APR changes does not apply to the following situations. An APR may increase after the expiration of a specified period of time if the account opening disclosure specifies the time period and states the increased APR. And 2, a variable rate APR may increase if it is tied to a publicly available index that is not within the institution's control. 3, the APR can increase for a category of transactions that occurs at least 7 days after an advance notice is given to the consumer of the increase. However, this exception does not apply during the first year after the account is opened. 4, an APR can increase if the institution does not receive the consumer's required minimum payment within 30 days after the due date. And 5, the APR can increase due to a consumer's failure to comply with the terms of a workout arrangement, provided that the APR for any category of transactions cannot exceed the APR that applied before the workout arrangement began. Protected balances. A protected balance means a balance to which an increased APR does not apply when the APR on the account has been increased under the advance notice exception. And 2, a bank may allow payments to be applied to a protected balance under one of the following methods, or a method that is at least as beneficial to the consumer. An amortization period of no less than 5 years starting from the date the increase rate became effective, or a required minimum payment that includes a percentage of the protected balance that is no more than twice the percentage that was required before the date the APR was increased. 3, a bank may not assess any charges or fees based solely on a protected balance. Unfair balance computation method. An institution may not use a 2-cycle billing method. That is, the institution may not charge a finance charge on any balance that is based upon a balance for days in the billing cycle that precede the most recent billing cycle as the result of the loss of a grace period. The following types of transactions are not subject to this rule. Adjustments to a finance charge as the result of the dispute resolution covered by Reg Z. Adjustments to a finance charge as a result of the application of the return of a payment due to insufficient funds. Unfair charging of security deposits and fees for the issuance of credit, or available on the account. Okay, and limitations for billing cycles. During the first billing cycle, a bank must not charge to the account security deposits and fees for the issuance or availability of credit that total more than 25% of the initial credit available on the account. Any additional security deposits and fees for issuance or availability of credit must be charged equally for over no fewer than 5 subsequent billing cycles immediately following the first billing cycle. A bank may not evade these requirements by providing the consumer with additional credit to fund the security deposit or fees for credit issuance or availability that would exceed this rule. And that does it for Regulation AA, that is. But there's an OCC letter that I still have to read about, and probably an FDIC letter that I still have to read about, so we're not quite done yet. Subsection 5, OCC guidance on unfair, deceptive acts or practices, defined here in the beginning as deceptive acts or practices may be deceptive if the following three factors are present. There is a representation, omission, act, or practice that is likely to mislead. Such representations, omissions, acts, or practices may include false oral or written representations, misleading claims about costs of services or products, use of bait and switch techniques, failure to provide promised services or products. The act or practice would be deceptive from the perspective of a reasonable consumer, is the second prong, and the third prong is the representation. Omission, act, or practice is material. Materiality means that the act or practice is likely to affect the consumer's choice. Now we go to unfair acts or practices. A practice may be found to be unfair if 1. It causes substantial consumer injury, 2. The injury is not outweighed by benefits to the consumer, or 2. The competition, and 3. The injury caused by the practice is one that consumers could not reasonably have avoided. Practices that may violate the Federal Trade Commission Act. The OCC has determined that the following practices may violate the Federal Trade Commission Act. 1. Failure to provide sufficient information to allow consumers to understand the terms of the product, or failure or service being offered without being misleading. 2. The failure to adequately disclose when significant fees or similar material prerequisites are applied to obtain a particular product or service being offered. 3. The failure to adequately disclose material limitations affecting the product or service being offered. D. Managing compliance risk. 1. Verify that information provided to consumers is complete, accurate, and not likely to mislead. 2. Avoid the use of such claims as guaranteed, pre-approved, and lifetime rates if there is a possibility that consumers will not receive the advertised terms. 3. Provide a clear, upfront disclosure of any contract provision that permits a change in the provision of the terms of products or services offered. Avoid engaging in promotions of a product or service that highlight a particular benefit if the benefit will be negated by another aspect of the transaction. 5. Review telemarketing scripts used to market products to bank customers for accuracy and to ensure that they adequately describe the terms, benefits, and material limitations of a product or service being offered. 6. Clearly notify consumers at the time of initial solicitation or free trial period, as well as subsequently, that the consumer must act to cancel a service at the end of the trial period. 7. Follow due diligence in selecting a third-party vendor. Make sure vendors are financially capable, and monitor vendor performance. 8. Ensure that contractual agreements with third-party vendors protect the bank against risk. 9. Ensure that promotional information and solicitations do not conflict with or contradict required consumer disclosures such as TLIP and privacy notices. Review consumer complaints and communications to determine if the consumer was misled. And maintain procedures to ensure that payments are promptly posted. 12. Monitor loan collections using collection calls made by third parties. Next page, 386. We talk about, it actually gives us subsection 6, the FDIC and Federal Reserve guidance on unfair or deceptive acts or practices by state charter banks. FIL 26-2004, which came after FIL 57-2002. Deceptive acts or practices. Acts or practices may be deceptive if the following three factors are present. There is a representation, omission, act, or practice that is likely to mislead the consumer. Such representations, omissions, acts, or practices may include false oral or written representations, including claims about costs or services or products, use of bait and switch technique, and failure to provide promised services or products. Failure to the act or practice will be interpreted by a reasonable consumer as deceptive. Written disclosures must be sufficient to correct a misleading statement on representation, particularly where the consumer is directed away from qualifying limitations in text, or it is counseled that the reading directed away from qualifying information in text, or it is counseled that reading disclosures and enough. Oral disclosures or fine print may be insufficient to cure a misleading headline or prominent written representation. Now we're at the representation in which an active practice is material, meaning that the active practice is likely to affect the consumer's choice, and expressed claims will be presumed to be material, and an implied claim will be presumed to be material when it is demonstrated that the institution intended that the consumer draw certain conclusions based on that claim. And unfair acts or practices. A practice may be found to be unfair if it causes substantial consumer injury, which can be outweighed by countervailing benefits to the consumer competition. Injury could not have been reasonably avoided, and the court may consider whether a practice would violate public policy when deciding if it is unfair. And other laws, violations of Section 5 of the FTC may also violate other federal or state laws. Technical compliance with other laws may violate Section 5 of the FTC Act. Note particularly truth in lending and truth in savings. Advertisements of guaranteed or lifetime interest rates could mislead. Advertisements of guaranteed consumers when the institution intends to change the rates, whether or not the disclosure satisfies the technical requirements of the Truth in Lending Act, the Truth in Savings Act, and Equal Credit Opportunity Act, Fair Housing Act, Fair Debt Collection Practices Act are also things where you could get a violation both ways under udaap and Section 5 of the FTC, as well as, truth in savings, truth in lending, POA, Fair Housing, Fair Debt Collection Practices Act. Only half a page, three-quarters of a page left. We have managing risks and enforcement. Enforcement, luckily, is the same fear of penalties that we've seen for everything else. For managing risks, there's what banks should review and things they should also do. So they want to review all advertising, solicitation materials, and customer agreements to ensure that they are fair and do not misrepresent terms. All material limitations or conditions on the terms are available of products or services are clearly disclosed. They inform customers about fees, penalties, or other charges, as well as limitations on any offers. They inform customers of contract provisions that permit changes in the terms of the agreement. They inform customers when terms approved by the bank are less favorable than those advertised or disclosed. Advertisements are tailored to the level of sophistication of the audience, and they avoid representations that the customer may pay less than the minimum amount due without disclosing any fees that result from such action. You clearly disclose the telephone number and mailing address that customers may use to contact them. And banks also should ensure that servicing collections are fair and responsive to customers, manage and monitor employees and third-party service providers to ensure that customers are treated fairly, review compensation agreements for bank employees and third parties to ensure that there are no unintended incentives to engage in unfair practices, monitor compliance with policies, and implement procedures for receiving and addressing consumer complaints with respect to their for the usual $7,500 per day for violations, $37,500 per day for unsafe and unsound practices, pattern of misconduct that causes some gain, and penalties of $1.375 million per day against persons who are knowingly causing fraud.